今切り替え中ですかね。あ、今出てきました。
OK です。OK。はい、皆さんこんばんは。知財実務オンライン第266回 Two Years of the Unified Patent Court Case Law and Practical Advice ということで、お届けいたします。ナビゲーターは
鹿島でお送
大谷
りします。
と
よろしくお願いします。
お願いします。さあ、鹿島さん、12月のプログラムをお願いします。
はい、12月が、最終週18、12月18日まで3週にわたってお送りしたいと思います。先週がですね、オランダのこちら AOMB 事務所の石黒先生をお招きしまして、オランダ特許制度についてお話しいただきました。で、本日がですね、ターメア、事務所のお二人、ルミ博士とクラウディアさん、にお話しいただくのが、統一欧州特許制度というところでございます。はい。そして来週月曜日が第10回ライブライトニングトークということで、こちらまだ募集中というところありますが、1人5分間のライトニングトークをオンラインで行いたいと思います。12月18日最終、今年最後の鳥となりますが、島津製作所の阿久津さんをお招きしまして、知財実務における生成 AI プロンプトドリブン改革をお送りする予定でございます。12月年末お忙しいと思いますが、ぜひご覧いただければと思います。
はい、ありがとうございます。あとはですね、次のスライドなんですけど、これが何回か告知しているライトニングトークでして、来週の月曜日19時半からということでございます。まだ少し枠が残ってますので、よろしくお願いします。はい。まだの方、申し込みフォームからやってもらえるとありがたいです。さあ、ということで、本日ゲスト紹介なんですけども、ゲスト紹介までは日本語でやります。で、セミナーの内容は英語です。で、今回は、通訳の方が特にいないということで、我々が、日本語で解説を入れさせていただくということです。で、日本語の解説は、一枚一枚のスライドでやるっていうよりは、ブロックごとに、第1章、第2章っていう章ごとにやろうと思ってますので、章の最後に、その章の、簡単なレビューをまとめを日本語でやろうと思ってます。で、逆にそのご質問とか、あとコメントについては、英語でも OK ですし、日本語でも OK です。日本語で書いていただいたら、我々がそれを英語にしてお二人に投げようと思ってます。はい。ということで、じゃあ、ここからゲスト紹介でございます。一人目はドクター・ルイジーさん、ルイジー・ルミということで、ルミさんのプロフィールはこちらです。で、英語だとやっぱちょっと読むのが大変かと思うんで、日本語版を追加しております。で、ルミ博士はですね、2005年に、フライブルクという場所、ドイツのフライブルクの大学で、科学ですね、ケミストリーを修了されておりますと。で、そもそもですね、生い立ちが、ミラノということなんですけども、今の、そうですね、イタリアとドイツというところで、いろいろ、様々な言語を使うことが可能です。で、2009年より知財実務に従事ということなんですけど、今だとドイツ弁理士と、あと欧州の商標意匠弁理士、でそして欧州弁理士と取っています。で、2年前には UPC の代理人としても登録されています。で、ここで欧州の場合、ドイツ弁理士っていうのは特許と、商標と意匠全部扱える資格なんですけども、欧州の場合はこれが2つに分かれてます。で、欧州は、特許弁理士と、あと、商標、意匠弁理士っていうふうな2つに分かれてて、で、片方だけ取ってる方が結構多いんですけど、ルミさんは、全部取ってるということなんで、あらゆる案件を扱うことが可能です。で、続きまして、こちら、クラウディアさんです。クラウディアさんはですね、同じように科学を大学で学ばれて、で、その後、研究所に移られております。で、2015年に知財分野に関わるようになって、で、現在はドイツ弁理士、こちらは特許の弁理士です。特許、商標、遺書全部扱える資格です。と、あとは欧州のこちらパテント後に特許の弁理士。で、そして UPC の代理人として登録されておりますということで、お二人ともすごく経験豊富な専門家ということでございます。こちらが、お二人の所属されているターメア・シュタインマイスターというパテントファームです。 でドイツ語、日本語だとパテントアトニーズなんですけど、ドイツ語だとパテントアンバルテだったかなみたいな感じで、で、ですね、場所で言うと、オフィス、メインのヘッドクォーターがミューニック、ミュンヘンにあります。で、こちらミュンヘンっていうのは、ドイツの、一番でかい、都市で、首都ではないんですけど、一番でかくて、で、ヨーロッパの、ドイツの裁判所とか、知財系の機関っていうのが一番集中しているところです。で、ブランチがビエルフィールドってところで、これドイツの北部の方にあるんですけども、2つの事務所、拠点を持ってて、トータルで言うと60人ぐらいの規模の事務所となっております。で、ウェブサイトにはフィロソフィーとか、あとチームメンバーについていろいろと書いてますんで、興味ある方はぜひそちらもご覧ください。で、本日コーヒーブレイクが2回あります。で、質問ですとか、あと、もろもろについては、日本語でも結構なんで、せっかくの機会なんでね、ぜひ書き込んでいただけると幸いです。はい。ということで、トップシェアで。Okay, so Dr. Luigi and Claudia, so would you please start your presentation?
Yes, thank you. I will share immediately.
Okay. So, good evening from Meer Steinmeister from Germany to Japan. Dr. Rumi and me are very happy to have the opportunity to give this talk today. And we also would like to start off with a very short introduction of our law firm, but we understand that Oshitani-san has already presented a few facts about our firm. So, to be very briefly, the history of the law firm is as follows. It was founded in 1973 by two persons, Mr. Meer and Mr. Steinmeister. So this was a time when neither Luigi nor me were present already or on Earth, you know. And it was founded by both persons on equal terms. However, we nowadays like to call ourselves Meer. So our apologies to Mr. Steinmeister. We like to call our IP firm Meer, which is more concise and memorable. Our first contacts to Japan were already in the 70s, and since then we've been steadily growing and now have about 25 patent attorneys with at least 2 qualifications as European and German patent attorneys, and more recently also as UPC representatives. And we are 62 members in total with all employees counted. Then we would like to show you a little bit where our offices are located in Germany on a map. So you see in the lower right corner a map of Germany, and Dr. Rumi and me are located in the very south of Germany, Munich, which is famous for the Oktoberfest, but which is also a city that is very important in intellectual property. And we have a very small branch office, as Oshitani-san already mentioned, in Bielefeld, which is rather to the north of Germany, indicated with a red point on the map, which is smaller than our office, and where there are more family-driven business clients that we are counseling. So you can see most of the patent attorneys of our team on this slide, covering all fields of technical areas. As you will see on the next slide, our technical expertise covers electrical and communication, automotive, mechanical, AI and computer implemented inventions, life science, medical, chemistry, and pharmaceutical. Rumi-san and me are rather on the chemistry part and are responsible for this area. Our legal expertise also covers several matters like patent drafting, so drafting new applications, then prosecution of patents in front of the EPO or German Patent Office. But we also do the smaller sister of the patent, like utility models, and also trademark and designs, if you have some aesthetic things to apply for. Then we are active in opposition and litigation, and we are covering the whole set of matters here. And I would like to hand over now to Rumi-san to dive into the topic of today's talk.
Yes, thank you, and welcome to everyone who is listening. I know that some friends from Japan are now listening to this webinar, so welcome. I hope you will enjoy this presentation on the UPC. So here in this slide, you see the overview of the topics we are going to cover this evening, Japanese time. We will start giving a short summary of the unitary patent and the unified patent court. Then we will move on with some strategies for applicants and patentees as regards opting out and the filing of unitary patents, yes or no. Then we will very briefly touch upon some trends at the UPC now after 2.5 years. And finally, the last chapter is directed to the case law, to relevant decisions of the UPC, which in our view might be interesting to the Japanese audience. So let's start with the first chapter with unitary patent. I think most of you will know what the unitary patent is. The unitary patent is a patent which, with a single patent, covers 18 European states. So by requesting a unitary patent, 18 European states are validated as a single entity. And this option adds a further option, a further validation option for clients after the grant of a European patent. Importantly, for applicants, nothing changes. So you file a European patent application as you did before, either directly with EPO or you enter the European regional phase of a PCT application. And up to the grant, nothing changes. After the grant, you will have to make a decision whether you would like to request a unitary patent or whether you rather prefer to go the traditional classic validation route and validate your patent only in specific European countries. However, as you know, some countries are covered by the unitary patent, other countries are not covered. So for the countries which are not participating in the unitary patent, you need to validate them as usually as you did before. So here on this slide, we summarize the 18 member states which are covered by the unitary patent. So if you request a unitary patent, you get a patent covering these 18 countries. Among them are large, important markets like France, Germany, or Italy. Unfortunately, there are some major countries, major markets, which are not covered yet by the unitary patent. Of course, Spain is an important country which is not covered by the unitary patent. So if you would like to have your protection in Spain, you have to validate Spain via the classic route. And of course, as regards non-EP states, the UK is an important market which needs to be validated by the classic route, because as you know, UK decided to exit the European Union, so they cannot be part of the unitary patent. On the next two slides, we show in two charts or two graphs, we highlight basically the countries which are covered by the EPC. So these are in 39 in red are the 39 EPC member states. So you can each validate them classically. So when you grant it, you have a European patent, you can validate your European patent in each of these 39 member states. And of these 39 EPC states, only 18 are participating in the unitary patent, and these are the blue countries which are shown on this map. So 39 EPC member states, 18 states participating in the UP. So it is clear that there are 21 states which you have to validate classically anyway. As regards the costs, because we have been asked many times when it is from a cost perspective more advantageous to request a unitary patent. This is a table which I copied from the EPO page, and the EPO claims that when you compare the costs of a unitary patent for the years 5 to 10 compared to validating 4 countries via the classic route, you save about 30% of costs. So what the EPO says is that a unitary patent is, cheaper than validating your European patent in 4 countries. So the borderline is 3 to 4 countries as regards the costs. But as we will see later, costs is one criteria for deciding whether to file, whether to request a unitary patent or to validate your patent in several countries. We will see that later. But for the applicants, when they have a granted patent, they basically have to decide whether they would like to request a unitary patent or validate the European patent via the classic route. And the first thing that the patentee has to do is first to think of the countries in which he would like to have a protection, and then look at which countries are or can be covered by the unitary patent, which cannot be covered or are not covered by the unitary patent, and then see whether a request for a unitary patent might make sense. Oshinari-san, perhaps you would like to briefly summarize this chapter in Japanese, if you would like.
Okay, thank you, so, Dr. Rumi. This is very easy to understand. Thank you so
Okay.
much. ここまでが第1章ということで、UPC のですね、簡単なご説明ということでした。UPC というか統一特許ですね。ユニタリーパテントの説明ということです。でユニタリーパテントっていうのは、単一の、欧州の単一特許というふうに訳されるんですけども、単一効力っていうのが発生しますと。で、単一っていうのは更新の費用も単一で、登録手続きも単一ということですね。で、欧州には、結構、EP に加盟している、30カ国以上の国がいるんですけど、現状、ユニタリーパテントでカバーできるのは18カ国、18 countries ということでございます。基本的にはよく使われるところで言うと、フランス、ドイツ、イタリアあたりは、あとオランダとか、そのあたりはユニタリーパテンツでカバーされるんですけども、スペインとか、あとは、英国、UK ですね。あとスイス、ノルウェー、トルコ、このあたりは現状だとユニタリーパテントのカバー外ということです。で、最も重要なところ、今の第1チャプターで重要なところとしては、ユニタリーパテントの費用っていうのが、だいたい4カ国個別にバリデーションした費用よりも安くなる傾向があるということです。なので、ボーダーが3カ国で、 4カ国、5カ国、6カ国というふうにバリデーションを考える場合は、ユニタリーパテントで一発でいっちゃった方が、コスト的には安くなることが多いというところでございます。まあ、あとそうですね、第1章で言うとここまでですかね。Okay, Dr. Ruli, here is a brief summary of chapter 1. So please go
Okay.
ahead, next chapter.
Thank you. Next chapter is directed to the Unified Patent Code, the UPC. Sorry. So for the new patent, the unitary patent, a new court needed to be established for handling this new patent. And this is the reason why the Unified Patent Court was provided. This is a court which provides centralized litigation procedures for the 18 UP member states, so for the member states which take part in the unitary patent. The court deals with infringement actions, with provisional measures, with revocation actions, invalidity counterclaims, so with every action which involves unitary patents. And I know you are aware of the fact that the UPC has several local divisions, regional divisions, central divisions, and we do not plan to go in that detail today, but keep that quite broad. As regards the responsibility of the UPC is responsible, as I said, for unitary patents, which have been granted on or after June the 1st, 23, and for a transitional period, also from classic European patents, which have been validated but have not been opted out. During a specific amount of time, which is 7 years and might be extended by further 7 years, you can opt out your classic EP patents, which have been validated classically, and you cannot opt out these patents from the responsibility of the UPC. So as an example, your patent has been granted, let's say, in 2010, and you have validated your patent in Germany, France, and Italy. If you opt out these 3 countries from the UPC, a competitor can attack your patent only nationally. Your competitor cannot attack your patent centrally at the UPC. Whereas if you have not opted out your 3 EP patents, then a competitor has the choice. He can decide whether to attack your patents centrally at the UPC for all 3 countries, or nationally at each national patent court. So the decision whether to opt out or not opt out has an impact on the litigation of your patent. So which decisions are required by patentees? Well, you have to decide which of your patents should be allowed to participate in a centralized UPC litigation, for example. And for example, if you have a patent which is important and rather weak, then it might be a possibility to opt out your patent. What is very important to keep in mind, because we see that some lack of clarity, is that you cannot opt out a unitary patent. So if you have requested a unitary patent, you are sticked to the UPC system. So the option to opt out applies only to classic EP patents which have been validated, but not for unitary patents. That is very important. Okay, Shitani-san, would you like to summarize, or shall I move on to the next
Sure,
chapter.
thank you so much. チャプター2のお話をしていただいたということでございます。で、チャプター2は、統一裁判所のお話ですね。で、UPC というところで、ユニファイドパテントコートのお話でございます。で、UPC っていうのは、ユニタリーパテントに関する争い事を審理する裁判所となっておりまして、現状だと18カ国の、および将来の3カ国を対象とする、単一の裁判所でございます。事件の類型としては、いわゆるそのインフリンジメントっていう侵害訴訟と、あとは仮処分ですね、プロビジョナルメジャーズとか、あと無効取り消し、このあたりについて、責任を持って管轄しているということです。で、UPC の管轄っていうのは、2023年の6月1日以降に付与されたユニタリーパテントと、あと、ここ重要なんですけど、オプトアウトしていない、いわゆる従来型の、ヨーロピアンパテント欧州特許の各国部分、これが管轄です。で逆に、UPC が管轄しない案件としては、オプトアウトされた後の従来型のヨーロピアンパテントの各国部分というふうになっております。それはそうですね。オプトアウトするってことは、単一特許じゃないことを選択しているので、オプトアウトしてない従来の、ヨーロピアンパテントと、あとユニタリーパテント、この2つが UPC の管轄ということになっております。で、結局その意思決定としては、そうですね。オプトアウトするかどうかっていうのは非常に重要で、で、そのチャプター3から、オプトアウトすべきかどうかっていうのを含めて、お話があるかと思います。以上です。Okay, so please, next one,
Okay,
please.
thank you. We come now to this third chapter, recommended strategies. This is the last chapter before the first coffee break. So here we concentrate on two questions, which are important for applicants and for patentees. The first question is whether to opt out your classic EP patent, yes or no. And the second question, whether to request a unitary patent or rather validate your EP patent classically only in some countries. So as regards the opt-out strategy, basically it's a decision which needs to address the balance between the advantages and the disadvantages of the system of the UPC. So balance has to be found between the advantages of using the UPC, and clearly the main advantage is that you have one trial centrally at the court, which which impacts many countries. So you have an infringement. You may file an infringement action centrally for all European countries of your EP patent. You can basically have the advantage that you do not need to file several infringement actions in several national countries. Of course, there are also disadvantages of being in the UPC system. And as a patentee, the greatest disadvantage is that your competitor might file a centralized revocation action, possibly as a revocation counterclaim. If they receive an infringement action, they might file a revocation counterclaim centrally at the UPC. And if the UPC decides that your patent is invalid, then with a single action, you lose your patent in several countries. So you really need to find a balance between the advantages and disadvantages. Here on this slide, we listed the arguments for an opt-out and the argument against an opt-out. And basically, we think that there are more arguments for an opt-out than against. But of course, this is a decision which needs to be taken on a case-by-case basis when looking at the patent. So arguments for the opt-out, as I said, it avoids a central attack before the UPC. The second bullet point is perhaps not so relevant anymore. At the beginning, we said, well, we have here an unexperienced court, which is a new court. We have new senates, new judges, which of course they are experienced on a national level. But in this new court, they don't have any experience working together. You have to shape the case law. So there is a certain level of uncertainty how the court will decide. And so opting out prevents decisions from this court. Also, an advantage is that once you have opted out your EP patent, if you plan to file a central infringement action against your competitors, for example, you can withdraw your opt-out. Unless, however, and this is very important, unless a patent is enforced or attacked in a national court. In that case, you cannot withdraw your opt-out. One disadvantage or one argument against opt-out refers to the higher litigation costs in case of multiple national actions. So if you opt out and you decide to litigate your patent nationally, then you might have more money to spend compared to a centralized UPC litigation action. But that, again, depends on several factors, which we will briefly discuss here in this table, which summarizes basically, in our view, the options and the decisions that the patentee has to make as regards the opt-out strategy. So I think one decision that the patentee has to make is to divide the patents in commercially important patents and less important patents, and then try to categorize the patents as regards their strength, as regards their validity. And this is, I think, the most difficult part to determine, to assess the validity of a patent. And what we recommend is, if you have a strong patent, a strong patent as regards validity, then the risk to lose your patent in a centralized revocation action might be quite low because of the strength. And so, as an option, we say, well, then you do not really need to opt out your patent, in particular if you plan to sue your competitors. If you know you have several infringers in several countries covered by your patent, by your EP patent, then an option could be not to opt out your strong patent and use the UPC to file a centralized infringement action against your competitors. In that case, you have the advantage of a centralized UPC litigation, and you minimize, or you have a low risk of losing your patent in a revocation counterclaim. However, if you have a rather weak patent, or where you do not really know whether your patent is strong or weak, then it might be preferred to opt out your patent in order to avoid a centralized revocation action by your competitors. And here you have to, well, maybe you have to file infringement actions on a national level. You might have higher costs, but at least the risk of losing your patent in all EP countries is lower. And the same thoughts you might have for less important patents from a commercial perspective. But the guideline would be, if you have a strong patent, then rather not opt out. If you have a rather weak patent, or where you do not know how strong it is, go on the safe side, be on the safe side, and opt out your patent. And we saw in the last 2.5 years, and also shortly before the UPC started, but many patentees decided to opt out their patents because they feared to receive a revocation action at the UPC to lose their patent. However, in the last year, we believe and we see that less and less patentees, applicants opt out the patents, the applications. I think there are two reasons. The first reason is that the risk of having a revocation action at the UPC is quite low because the costs are very high. So for opponents, it's cheaper to file an opposition proceedings at the EPO. And the second reason is that we believe the people are seeing that the decisions which have been made and issued by the UPC in the last months, last 2.5 years, they are quite reasonable decisions. And so there's one our thought. People are thinking, well, UPC is making decisions which are good, and so there is no need to opt out because we do not have to fear very crazy decisions. But this is just our hypothesis. So as regards the filing strategy, and therefore basically the decision whether to request a unitary patent or validate the patent in several European countries, which are basically covered by the UP. Well, this decision depends on several factors. Depends on the commercial importance of a patent, on the strength, on the country scope, and of course on the costs. As a rule of thumb, as I said before, from a cost perspective, if you would like to have a protection for your patent in at least 3 to 4 countries, which can be covered by the unitary patent, then from a cost perspective, you might decide or might prefer to requesting a unitary patent, because on the long term you save money. However, there might be other reasons against a unitary patent. One reason is commercial importance and the strength. If you have a very strong or very important patent which is strong, and you know that you might have some competitors attacking your patent, if you file a unitary, or if you request a unitary patent, you might get a revocation action at the UPC. And if you have a strong patent, then the risk of losing your patent, a unitary patent, might be low. If you think that your patent is rather weak, then the risk of losing your patent at the UPC with a centralized revocation action might be quite high. And so, as for the previous chart, what we recommend is if you have a strong patent, then you might request a unitary patent, because the chances of losing that patent at a centralized revocation action might be quite low. Advantage, of course, you have one patent covering 18 countries. You can do a lot of litigation, centralized litigation. If your patent is rather weak, then it is probably better not to risk going into the UPC system to requesting a unitary patent. Then it is better perhaps to validating the patent in several European countries without requesting a unitary patent, just to reducing the risk of losing your patent in a centralized revocation action. One thing that I believe is also important to keep in mind is that during the course of a patent, and we see that very often for classic patents, during the life of a patent, let's see a classic patent, patentees lose interest possibly in the patent. They lose interest in the patent, and they would like to pay the renewal fees only for some countries. And I give you an example. Your patent is validated, let's see, in 10 European countries. And after 10 years, the patentee thinks the patent is not relevant anymore in all these countries, but I would like to keep my patent in, let's say, only Germany and France. With a classic patent, he can do so because the renewal fees of the classic of a European patent which has been validated classically have to be paid at the national patent offices. And so the patentee has a flexibility to decide which part of a European patent to renew and which not. So he can decide, our patentee can decide after 10 years to pay the renewal fees only for France and Germany, and not to pay the renewal fees for the other 8 countries for which he had validated the patent. Now, if you have a unitary patent, the problem is that you pay just one renewal fee. And if you do not pay this renewal fee, you lose your unitary patent. So you lose your patent covering 18 European countries. So by requesting a patent with unitary effect, you lose some sort of flexibility when it comes to renewing the patent. And this is something which the patentees also need to keep in mind when making their decision whether to request a unitary patent or validating the patent in several European countries via the classic route. All right. So we come now to the first coffee break, and I give over to Shitani-san.
Okay, thank you so much. Oh, what a nice slide, right? You remain a Japanese character, coffee break.
Yes, so this slide has been prepared by ChatGPT. I asked him to draw me a figure of a anime drinking a molded wine at the Christmas market in Munich, and this is what ChatGPT produced. So here in Munich, of course, December is Christmas time of Christmas markets, and there is a very large Christmas market in front of the town hall, which is represented here on the right. This tower is the tower of a town hall with a very big, beautiful Christmas tree in front of it. People gather there, drink molded wine, have some fun, drink molded wine, eat sweets. And this is depicted here on this slide. So ChatGPT did a very good work, I would say.
Thank you so much. このコーヒーブレイクのスライドは、我々がお渡しした元々のデフォルトのコーヒーカップがついてるやつをベースに、真ん中の絵はチャット GPT で作ったということです。で、GPT で作ってるのが、これクリスマスマーケットを楽しんでる、少女の絵ということで、マーケットの中ではこんな温かいホットワインとかを楽しみながらいろいろとブラブラできるということですね。はい。じゃあ、チャプター3のサマリーをまずお話ししようと思います。で、チャプター3なんですけども、かなり重要なスキームなどがお話しされていたかと思います。で、先ほど、統一特許と、あと統一裁判所のお話があったんですけども、チャプター3では、オプトアウトすべきかとか、あとは、単一特許で出すべきかどうかっていうところの考え方をお話しいただいてます。でやっぱりそのオプトアウトするってなった場合のメリットとしては、当然その1回の手続きで、ごめんなさい、単一特許のメリットは1回の手続きで、カバーできるんで、侵害とかの手続きが1回で済むと。なんで効率化されます。で、コストも安いですと。で、一方で、そのデメリットとしては、やっぱり一発で壊されてしまうと、一発で特許自体がもうなくなっちゃう。 なので、ある種セントラルアタックみたいな感じで、一回潰されたらもう終わりということですよね。うん。で、オプトアウトするかどうかの考え方っていうのが18ページのスライドにあります。Dr. Rumi, can you share page 18, opt-out matrix? Oh, thank you so much.これ、4証言、2証言で自分でグラフ化させても見やすいかと思うんですけど、特許の、強さですね。ここでいう、上の validity ってところが、要は、無効理由、無効審判とかかけられても耐えれるかどうかっていう意味です。で、無効審判とか仕掛けられてもしっかりと守りきれるようなのが、このストロングバリディティって書いているところで、有効性と呼びますけど、で、この特許の有効性が高くて、かつ、このコマーシャルインポータンスっていう商業上の重要度が高い。特許も潰されにくくて、で、事業上、ビジネス上大事な特許っていうのは、これはもうオプトアウト不要ということですね、一番左。で、なぜかというと、やっぱり、潰されにくいんだったら、その強力な特許で、他国同時訴訟っていうのを、まとめてやれるというところがあります。で、一方で、潰されにくいんですけども、あの、あ、順番でいこうか。で一方で、商業上重要なんだけど、潰されやすそうだなとか、ちょっと無効資料ありそうだなっていうものは、オプトアウトをやった方がいい。ビジネス上重要でも、潰されたらもう終わりなんで、セントラルアタックのごとく一発で終わるんで、若干ちょっとこれ、登録なるか、無効にされる気配があるなって思ったら、オプトアウトして各国バラバラにしといた方がいいと思います。で、そうすると、一カ国で潰されても、他の国ではまだ残るっていうことになりますね。で、右から2番目のところ、これは、有効性は強い、特許の、防御力、潰されにくさは強いんだけど、ビジネス上そんな重要じゃないっていうものですね。これは原則不要と、ノーって書いてるんですけども、基本的にはいりません。つまり、単一と、オプトアウトせずに単一特許のまま残しておいた方がいいということです。これは主にコストメリットの観点からです。で、一番右のところ、これが、ビジネス上は、そんなに重要じゃないんだけど、有効性も弱いと、ってとこですね。これは、オプトアウト、maybe って書いてるんですけど、ケースバイケースってところですね。で、その後、Dr. Rumi, please share page 20. Thank you. で、この18ページと20ページの間に、UP 選択すべきかってところのスライドが1個挟まってて、それが観点としては費用にするかとか、あとその4カ国以上で権利化を求めてるかとか、そのあたりが考える必要があると。で、今提示していただいているのは、そうですね、ちゃんと出願して、ちゃんと権利化判断の話なんですけど、これはですね、基本的には先ほどのオプトアウトするかっていうところの、裏返しというか、ほぼ表裏一体みたいな表になってます。で、一番左が、有効性が高い権利で、かつ商業上の重要度が高いっていうと、当然にこれはユニタリパテントの方がいいでしょうということですね、これ。うん。で、理由は、オプトアウトのところと一緒です。で、脳のところ、これも一緒ですね。有効性が弱くて、商業上の重要度は高いんだけど、えっと、まあ、潰されやすそうだなっていうものは、やっぱりセントラルアタックを回避するために、単一特許はやめた方がいい。従来型の権利とかにした方がいいですということです。で、さっきと唯一違うのが、ここのmaybe ですね。レスのところ、一緒か。このローやから、商業上は重要度が低くて、で、かつ、防御力も高かろうが低かろうが、商業上が低い、商業上の、重要性が低いものは、UPC で、ごめんなさい、単一特許で出すかどうかっていうのは、ケースバイケースということです。はい。これ、非常に重要な判断のマトリックスのスキュームだと思うんで、ぜひ皆さん、特にこちら覚えていただければと思います。OK。 this is a summary of chapter 3. Thank you for your presentation.
Thank you.
Here we picked some questions from listeners. At first, 杉浦さん、ありがとうございます、ご質問。First question is, how are AI and data-related patents handled in European Patent Office and UPC?
Could you please repeat the question?
Okay, AI-related patents. How are AI-related patents handled in UPC or European Patent Office recently?
With AI-rated patents, there are these Debus decisions at the EPO. And if I remember correctly, when the inventor is AI, is not human, they are not accepted. So from my understanding is that the EPO and I don't think that there are any decisions of UPC yet on AI. They require that the inventor is human, not AI, and so they are not accepted at the EPO.
Thank you so much. デイビス事件っていうのがあったんですけど、AI が発明者の場合だと、それは特許として、有効でないっていうふうに判断されてるんで、それは認められませんっていうことでございます。ちょっとそれに加えて追加の質問、インベンターが人間だけど、AI 使ってる発明はどうなんかっていうのを今から聞いてみます。Dr. Rumi, thank you for your advice. We know Davis cases, but this case is related to maybe only for inventor, right? So how about what if the inventor is a human, only human, but the contents of technology is related to AI. So in other words, AI using AI apps or AI algorithm itself. So how the EPO handle or treats this kind of AI-related apps or some kind of system?
Well, that's a difficult question because I'm a chemist and I'm not an expert of
Exactly.
computer implemented decisions. I would say that you could be difficult because you need to show some technicality. So you need to show that your AI invention is used for some technical purpose. If you are not able to show that, I think it will be very difficult to get a patent. And I don't know whether my colleague has some additional comments to make. I would say if it's not technical, then you don't have a possibility to patent such a AI or a invention directed to AI.
Okay, thank you so much. そうですね。ルミさんもともとケミストリーがご専門なんで、AI について、そこまで、具体的な話はちょっと難しいということなんですけど、そうですね。やっぱり一般的には、コンピューターによる意思決定というか、ソフトウェア関連と同じように、テクニカルなものです。技術を使ってますっていうところをちゃんと審査官に示す必要があるということです。で、その技術的な目的っていうのがきちんとクレームなり、明細書に組み込まれていなければ、それは特許の取得っていうのは非常に難しくなるということです。その日本に比べてね、もともと欧州はかなりこのあたり結構厳格なんで、そのあたりはまた随時いろいろと情報収集をしていただけるとよろしいかと思います。杉浦さんご質問ありがとうございました。Here's a second question. Wait a minute. 二つ目。Okay, so maybe both of you majored in chemistry. So what inspired you to study the chemistry, Dr. Rumi and Miss Claudia? So would you explain?
I had a very good chemistry teacher at school,
Mhm.
and that was the reason. And I always liked mixing stuff at home, and so that was the reason why I decided to study chemistry.
Thank you so much.
And for my part, I more enjoyed the calculation part to understand quantum mechanically how it works a little bit. So more from the physics perspective. And maybe because of that, I may also add for the AI question, AI-related inventions, that you may have to distinguish between whether it's an AI-related invention that really has the focus on the architecture of the AI, so it does something in the computer architecture, or whether it's just an applied AI invention to a specific applied to a specific topic. And at the EPO, there is often the difficulty and the hurdle to take that this in the end is not a mere representation of information, so that the technical effect is indeed technical and is used to automatically, for example, control a process or something like that, not just to prompt or display a result.
Okay, understand. Thank you so much. まず、ルビさんが科学専攻した理由は、単にその科学の先生が良かったからということで、学校の先生、科学すごく良かって、で、家でいろいろと、自分で実験もしたと。それが、科学学ぼうとした理由ですということです。非常に楽しんでましたということです。で、クラウディアさんが、その AI に関する補足の説明をしてくださったんですけども、基本的にその AI のアーキテクチャと、構造自体にちゃんと仕組みを当てれてるのか、あるいはその単に AI を使ってますよってだけなのかっていうところが、一つポイントになりますと。で、単に AI を使ってるってだけだと、とか、プロンプトを入れてるっていうだけだと、EPO としては、やっぱりそれが単なるその情報表現というか、なんか、テクノロジーじゃないっていう判断になるみたいですよね。で、テクニカルプロブレムなんで、技術的な課題に、アドレス、解決しようとしてるか、向かっているかどうかっていうところが、AI 発明として、AI 発明というか、そのソフトウェア発明として成立するかどうかっていうところだということでございます。はい。ありがとうございます。鹿島さん、なんか他質問ありますか？
はい、大丈夫です。
大丈夫ですか？
はい。
OK です。
時間もだいぶ悪い
そうですね。
出してるので、ちょっと早く
Okay, so thank you, Dr. Rumi and Claudia. So please proceed the next slide. Chapter 3?
Yes.
No, chapter 4.
Chapter 4, and I see that time is running out. We are running out of time,
No
so
problem.
I will keep this chapter very short. And these are some numbers of UPC after 2 years, and by the end of June, 900, almost 1,000 cases have been received by the UPC. That shows that I think the UPC has really been very successful, contrary to many people who thought this would not be the case. Here is a chart showing the number of the cases filed with the different locations. And one sentence, Germany is at the front of litigation at the UPC. Of course, we have almost 75% of infringement cases are handled at the German local divisions. This was expected because Germany has a long, was also before the UPC most important country for litigation in Europe, and this is reflected now by the numbers at the UPC. As regards the IPC classes, here you see that electricity is on the first place as regards cases at the UPC. Class G is physics, so Class G and H, physics and electricity, are the most important technical fields which are litigated at the UPC so far, at least in the court of first instance. Here, distribution of language, and you see that English now is spoken in more than 50% of the cases. In the first 6 months to 1 year, German was the largest, had the majority of the cases. Now it has been overtaken by English. So English and Germany are the most important languages which are spoken now at the UPC. Yes, and I think we can now move to the last chapter, which is, I think, the most important today. And I don't know whether, Shitani-san, you would like to briefly summarize chapter 4, or whether we should move directly to this chapter.
Okay, thank you so much. チャプター4では、もろもろのデータ、最近のデータっていうのをご紹介いただいてます。で、2年経ったんですけど、UPC が動き始めて、訴訟合計としては946件ですね。で、内訳としては、インフリンジメント、侵害訴訟が351件、あとはそのカウンタークレイムスっていうのが、無効審判に対するカウンターです。これが321件。で、単独無効、スタンダーローンの無効審判が68件というような内訳です。で、地理的な分布で言うと、結構そのミュンヘンが一番多くて、もう3、40%ぐらいですかね。で、次に、デュッセルドルフ、これもドイツです。で、あともう一つが、他が、マンハイムとかハンブルグっていうので、やっぱりドイツが結構多いです。で、その次にパリとかミラノとかハーグっていうところが入ってるぐらいで、ドイツだけで、75% 近くですかね。で、IPC で言うと、電気系が35%ぐらい、生活必需品が20%、で、処理、そう、輸送とか機械とかそっち系が15%で、ケミストリーが12%ぐらいです。で、半分は英語、で、40%がドイツ語、で、イタリア語、フランス語っていうのはもう7%ぐらいしか使われていないということです。Okay, it's done. So please go ahead.
So I would take over now. Thank you very much, Ashitani-san. The next chapter, as Luigi-san already said, is case law. And this is a very interesting chapter because, as we have now seen, the UPC is a new system, and the challenge is that its own case law still needs to develop, needs to be established. And we have different influences from different nations here because the court body or the committee is composed of judges from different EU countries, and therefore also has different national law and case law in mind. So question is what is the influence, what will the influence be of national case law on UPC decisions? And how do different national case laws and patent laws find a good compromise in the end for the UPC system, for UPC decisions? And what we can now say, since the UPC is now in force almost 2.5 years, that we have many decisions of first instance courts. But of course, the case law in the end is formed by the Court of Appeal, so the second instance, which we will abbreviate in the next slides as COA, Court of Appeal. And there now, in the meantime, have arrived some relevant decisions from the second instance that we would now like to go into more detail on the next slides. And we would like to start off with a topic that is relevant to infringement as well as to the validity side of the patent, the claim construction. There is one case called where Insulet was suing EO Flow for a device for administering insulin, so for patients that have a high blood sugar. And this is this decision that has now been decided in second instance, 768 from 2024, where it has been filed. So there are a few guiding principles on claim constructions have been agreed on. And I would like to briefly summarize the facts of this case, where Insulet has filed a request for provisional measures, including preliminary injunction against EO Flow. And in first instance, this was done or attempted in an ex parte proceedings at a first instance court. And the first reaction of the first instance court was that it refused the request of Insulet because it was not sure whether the patent was really valid. So it had some concerns about novelty in view of one prior art document. Insulet appealed this first instance decision, which led to this decision cited here and was heard by Rian Kalden, which is a very well-known presiding judge at the Court of Appeal. And the Court of Appeal actually then granted the preliminary injunction, finding that the patent is indeed valid. And a key part of this decision was on claim construction. What was very funny and interesting to read is that the defendant, EO Flow, tried to argue that the claim construction should be done according to their own party's expert. So they said, dear court, please adopt the claim construction as our party expert supports this in his party opinion. But the court then made clear that the skilled person is actually not a party expert, as written down here on the slide. Instead, the skilled person is a notional entity and is totally fictional person, and it cannot be equated with any real person in the technical field of the invention. Also, the court held in this decision that the interpretation of a patent claim is a matter of law, and the court has to construe it independently, as said, from the perspective of the skilled person. Another side aspect was how to interpret single features of a claim, the decisive features. So they must be interpreted in the light of the claim as a whole. They cannot just be separated and independently construed. And in this case, from its content, it was about this fluid administration device, and the question was whether the claim related to this device in an assembled state, as shown here to the right, so the whole device as it is depicted here, or whether it would relate to a disassembled state where the components are not yet mounted to each other. And so the court said, even if there is a single feature that might support the view that it is disassembled in Claim 1, it nevertheless held that in the overall context, the claim relates to, of course, a device in an assembled state, and it cited several other features and passages in the description to support this. So this was the finding in this case. Then there is another very important decision, which is even a little bit earlier, which was decided a little bit earlier than the one before. It's nanostring versus genomics. Maybe you have heard of this because it was the real one of the most important second instance decisions on the merits. And in this decision, the court ruled on the priority and relative significance of the claims, description and drawings. And in the end, concluded that the claim is not only the starting point, but the decisive basis for determining the protective scope of a patent. Of course, this does not mean that the interpretation of a claim does not depend solely on the strict literal meaning of the wording used. The description and drawings must always be used as an explanatory source. So not only when a term in a claim is ambiguous, but also always the description should be considered and consulted as a whole in order to explain the context of the invention and the protective scope. This should, however, not go so far that the claim would merely serve as a guideline and that its subject matter of the patent also extends to what the description and the drawings might suggest. So the claim is still the most decisive part of those three elements: claims, description, and drawings. And this was the finding of nanostring versus genomics, which was also in the headlines of this second instance decision. And then we now have a case pending in front of the second instance, which is a little bit deviating from our current EPO case law, which is Agfa versus Gucci. In this case, this is why we have pasted some pictures of bags and shoes here. Leather shoes is related to a patent covering a method for applying decorative elements to leather articles. And there is a specific primer needed in this method, which is of an achromatic color. And so the whole case revolved around the term achromatic. And in the first instance decision, the first instance was then concerned with the question how far the description should be consulted, and it held that the description definitions can narrow, but should not broaden the meaning of a term in a claim. And specifications in the description that are not consistent with the granted claims cannot serve as a basis of a broad interpretation of a claim, because here the claimant has invoked that the term achromatic should actually also be extended based on certain parts of the description to compounds that have a little bit of a color and are not fully achromatic. So the first instance here ruled that this cannot be done. The description cannot broaden the meaning of the term achromatic in the claim again. And this contrasts a little bit with EPO case law at the moment, such as the enlarged Board of Appeal decision 1 from 24, which has recently been applied in a way that whilst the description should always be consulted, this does not mean that narrowing description definitions should be imported into the claims. And we will see how the UPC case further develops this case law in the appeal that is currently pending.
Okay. Oshitani-san, would you like to summarize these two cases before
Okay,
I
sure.
go on?
Oh, well, I now summarize this part. So wait a minute. 今のお話だとケースロー、実際の判断について4つのケースをご説明していただきましたと。で、一番最初のケースが、インサレット vs EOF っていうところで、これはクレームの、解釈について争われてます。で、ですね、クレーム、当事者が、熟練者、スキルドパーソンっていうものに基づいて、ちゃんとクレーム解釈されないといけないっていうふうに主張してたんですけど、裁判所は、その当業者、日本でいう当業者っていうのは、いわゆる仮想的な存在であって、実在する人物ではないですと。だから当事者が選任した鑑定人、パーティーエキスパートっていうところは、熟練者っていう法律上の概念とは別ですと。で、さらに、クレームの解釈っていうのは、またはブローって言って法律上の問題なんで、パーティーエキスパートっていう鑑定人、自称、熟練者と言われてる人が何言っても、裁判所はその人の意見に拘束されませんと。 いうのが、でかいポイントです。で、2つ目のナノストリング対 10X ジェノミックスってところは、これはクレームが決定的に重要ですっていう話で、明細書と図面っていうのは常に補助ですっていう、エクスプラネトリーエイズっていう意味で使われるべきだと。で、あとはですね、クレームっていうのは単なるガイドラインではないんで、後付けで拡張しちゃいけないっていうのがポイントです。で、3つ目がこれ、アグファ対グッチですね、これ、グッチ。で、これは、現在、アピールペンディングって言って、アピールが継続中なんですが、明細書の定義っていうのは、クレームの用語の意味を狭めるっていう、限定解釈に使うことはあっても、広げる根拠にはなり得ないということですね。で、これは、この解釈は実は EPO の大合意決定とは実は逆なんじゃないかっていうような指摘がなされてるんですけど、現在アピールがペンディングっていうことで、またさらなる判断が待たれます。で、最後、このエキスパート VS ソウルバイオシスってところで、これはそうですね、これは、何やったかな、控訴審、アディットマッターっていうので、あの、2社を特許侵害で提訴したんですけども、それが1個の LED っていう構成を含むクレームでされていましたと。で、後からですね、追加事項を、何か構成を追加しようと思ってたんですけども、結局、付与された、登録クレームの主題っていうのが、出願時の明細書からちゃんと当業者が直接かつ一義的に導き出せる範囲を超える場合は、新規事項の追加に該当するっていう、ある種当たり前の判断ですね。これについても、現在、これはそうですね、追加アディティマターっていうのが、追加されたってことで、クレームが無効にされたというような内容となっております。はい。OK, so completes.
Yes, thank you. So the next decision we will discuss briefly is this decision expert versus solviosis. And this is the first decision on the merits as regards edit matter. So here we had a case directed to light emitting diodes, LEDs, and solviosis sued to companies for patent infringement on the basis that expert marketed a smartphone which incorporates a specific LED into the camera module, infringing the patent of solviosis. So the case was decided by the first instance, and here we had infringement was acknowledged, and also the validity. Then expert filed an appeal, and that went, of course, to the COA, and it was then decided. This is a very recent decision, if I remember correctly, of October of this year. So the claim of the patent is very, very long. I don't want to reproduce it here. The important thing is that claim 1 as granted was broad, and it encompasses LEDs with just one MESA. MESA, I'm not an LED expert, but a MESA, as I understand, is a sort of protrusion on the LED, which allows the flow of current. And the question, really the relevant question for edit matter was whether the application as originally filed disclosed a LED with a MESA in combination with all the remaining features of claim 1. And if so, the relevant question is whether the LED with just one MESA is disclosed in combination, in particular with feature 5.2 of the claim, which is directed to openings near the edge of the substrate. And that was the main question. The court trying to assess, first of all, the meaning of these openings. And that is somehow extraordinary, because here the court started with the interpretation of the claim, interpretation of the feature 5.2. Here's just an overview of the technical field of a sort of LED claimed, with the substrates, the first conductivity a layer, active layer, and with the number 150, the MESA etched areas. The claim was directed only to the LED comprising MESA etched areas, and it was undisputed that a LED with just one MESA would also have MESA etched areas. The Court of Appeal defined the legal test for added matter, and the Court of Appeal said added matter exists if the subject matter of a granted claim extends beyond what the skilled person would directly and unambiguously derive from the original application. And if you are familiar with EPO, with EP practice, you will immediately recognize that this legal test is almost identical to the so-called gold standard used at the EPO, namely this direct and unambiguous disclosure of features of amendments. And the COA also made clear that the same must apply also to divisional applications and to early applications in the chain. So the legal test was direct and unambiguous disclosure of a feature. So the COA then looked at the application as filed and saw that, or decided that there is no disclosure of a single MESA LED in the original application. The patentee referred to figures 24 to 26, arguing that the embodiment shown in these figures would disclose one MESA, and it would show also one MESA in combination with feature 5.2, namely with openings near the edge of the substrate. But the Court of Appeal said, well, we believe that this figure does not disclose one MESA, but even if it showed only one MESA, then this feature 5.2 would be missing. And hence, it would be missing a direct and unambiguous disclosure of LED with one MESA in combination with openings near the edge of a substrate. And so before making this decision, the Court of Appeal interpreted feature 5.2, referring to the decision which Claudia presented previously, this nanostring with genomics. So they looked at the technical teaching of the feature 5.2. What is the technical teaching, the technical effect basically of this feature? They looked at the description, and they came to the conclusion that the openings, they are relevant because they improve the current spreading on the LED. And they decided that there cannot be a MESA between the edge and the opening, meaning the openings must be at the edges of the substrate. There cannot be a MESA between the substrate and the opening. And this was missing basically in figures 24 to 26, which was argued by the proprietor, because in these figures you had one MESA, you might have one MESA, but the openings were not on the edge of the substrate. You had a MESA between the edge and the openings. And so this figure did not show an embodiment falling under the wording of Claim 1. And so what the COA concluded is that Claim 1 contains added matter, and it covers technical embodiments that are not clearly and unambiguously disclosed in the original application. This seems a very strict decision, but in our view, it is in line with EPO practice. EPO is very strict. You need really a direct and unambiguous disclosure. Of course, this includes not only explicit disclosures, but also implicit. But if you have an explicit disclosure, it's even better because then you don't have to argue with EPO. But here clearly, the application as filed did not disclose a specific combination of features that found their way into the claim one as granted. And so this decision, as I understand, is very different to how the JPO assesses added matter, which, according to our understanding, is not as strict as the EPO. So you have to keep in mind when you amend your patent at the EPO that you really need a direct and ambiguous disclosure. Otherwise, the patent might risk to be revoked at opposition proceedings, or if you come at the UPC in litigation, at the UPC. So, and with this slide, I end this section.
Okay, thank you so much. So at first, I summarize our last cases.
Yes.
ごめんなさい。先ほど、ようやく4件の事件について要約させてもらったんですけど、最後の事件、エキスパート対ソウル、バイオシスってところは、今から喋るところでちょっと私が先走って要約してしまってましたと。で、これ、先ほどの単一のメサ構造の LED っていう話なんですけど、これが、登録クレームには単一のシングルメサっていうので、規定されていたんですけども、そもそもその開示されているのか、単一のっていうのが開示されているのかっていうところが争点になってます。で、クレームの、登録されてた内容では、基端部の近傍の開口に単一のメサがあるっていうふうに規定されてたんですけど、ただ、出願当初の、図面とか見ても、そうじゃないだろうと。つまり、単一のメサっぽいのはあるかもしれないんだけど、なんかよくよく見ると、その開口部付近に単一のメサがあるっていうのは、少なくとも認められませんというようなところで、これは、結論としては、開口部、端部付近の開口部に単一のメサが存在するっていうのは、明細書と図面に開示されてませんっていうことで、これは新規事項の追加に該当して、無効になったというような内容でございます。はい、これがあれで、コーヒーブレイクなんですけど、ちょっと時間もあれなんで、1個だけ質問を取り上げさせていただきます。Okay, so Dr. Rumi and Claudia, we have one question. The question is, the structure of some new de novo proteins is proposed by an AI system. So, could you any challenges to get patent protection such protein created by AI in EPO? So that's the question. So how about Miss Claudia?
Could you repeat it? So a protein that is created by an AI?
Yes. And so de novo protein, the structure of a de novo protein is proposed by AI. Sorry, not created, only proposed in AI simulation. So how about this kind of AI proposed protein structures is treated in EPO, especially if this could be get a patent or no?
I think this would now rather be related again to the Dabus case law that Rumi-san cited before, because in this case, again, the AI system would be somehow the overtake inventor function. That's what comes to my mind at the moment. If it proposes the new structure, it is actually the creator of the new structure, or so this will be subject to the case law on AI inventors.
Okay, thank you so much. もうこれは先ほどのですね、誰だかな、デイビス事件やったかな。 なんちゃら事件、で言ってたことと一緒なんですけど、そもそも発明者が AI になるのかどうかっていうようなところが議論になるのかなというところですと、まあ、それはそうなんですけど、ここからちょっと、私の試験ですけども、AI に提案されたかどうかって多分わかんないんで、発明者が AI ですよみたいな感じで、まあ、言わなかったら、まあ、登録になるんじゃないかなと思うけど、鹿島さんどう思いますか？
はい、私もおっしゃったと同意見で、
そうですよね。
やっぱりそうですね、わざわざ願書とかに AI で作成っていうところは書かないですし、発明者を AI って書くと、それはもう登録認められないっていうところは、今までのあれですね、判例出ているっていうところありますので、まあ、それ以上の情報は多分、出願時に出すことはないのかなと思います。
はい、ありがとうございます。多分この辺ってまだまだ判例の蓄積が弱いところなんで、今後またウォッチしていくとよろしいかなと思います。すいません、ちょっと具体的なアドバイスができず。はい、OK です。Okay, so please go next or final topic, maybe final chapter 5.
Yes, we have some last decisions. We will try to summarize because it's already 8 o'clock in Japan. So this next decision is a very important one because it's the first decision by the Court of Appeal on inventive step on the merits. It's directed to a case, an antibody case. The claim, as I write here on the last bullet point on this slide, is directed to a monoclonal antibody or a fragment that binds at least one residue in the catalytic domain of a enzyme and inhibits the binding for treating several diseases like cholesterol-related diseases or reducing cardiovascular risk. The first instance revoked the patent. Then the patentee filed an appeal, and it was now decided by the Court of Appeal. And as I said, this is the first decision by the Court of Appeal on inventive step on the merits. They started by, well, drafting or highlighting the framework in which the UPC will assess inventive step in the future. So the first thing is to define the objective problem, namely from the patent as a whole, without hindsight. So you look basically at the patent and at the problem which is mentioned in the patent, and that is basically the objective problem. Then you identify realistic starting points in the prior art. So knowing what the problem is, you look at the prior art and see what kind of documents are in the prior art which are realistic starting points for the skilled person aiming at solving the objective problem. Then the COA says the solution to the objective problem is obvious only if the skilled person would, and not merely could, have taken the next step. And this would could is a very important difference or differentiation because the skilled person needs some sort of motivation for moving from the starting point and amending the teaching of the starting point in order to arrive at the claim subject matter. And the skilled person requires some sort of reasonable expectation of success. So just the possibility to arrive at the subject matter claimed is not sufficient. The skilled person needs a reasonable expectation of success. And the burden of proof to showing obviousness lies on the party asserting obviousness. So this is the framework which the COA set for the assessment of inventive step. And this is the legal framework which will be used by the Court of Appeal and by the UPC in general in the future. So this is really a very important decision because now we have more clarity on how the UPC will assess inventive step, namely by this framework. Now, if we briefly apply this framework to the case, to this engine, the Sanofi and Regeneron case. At the end, the decision of the first instance was overturned. The reason was a lack of basically of a reasonable expectation of success for the skilled person when starting from a realistic starting point. So what the COA said is there was a prior art document disclosing the relevance of a specific enzyme in the cholesterol related conditions. So this connection, specific enzyme and therapeutic indication was known, but it was not described that this enzyme could be targeted by antibodies and so to create an antibody based therapy. Of course, the development of antibodies was known at the time. So did the skilled person have sufficient motivation to develop an antibody therapy addressing this specific enzyme and addressing the claimed medical indication? And the COA said no, there was no reasonable expectation of success because this enzyme can function twofold. It can function extra and intracellularly. Antibodies, they function only extracellularly. So they can bind the enzyme only when it is outside of a cell, not if it works within the cell. And at the time, it was not clear how this mechanism of the enzyme was distributed between an extracellular and intracellular function. This means the skilled person did not have a reasonable expectation that developing an antibody therapy addressing the extracellular pathway of the enzyme would actually reflect in a meaningful therapeutic effect. And so the COA came to the conclusion that a lack of sufficient motivation was present in the case. The patent or the claim was based on an inventive step, and the patent was maintained contrary to the decision of the first instance. So this is the first case which applied this new inventive step framework. Now, this framework seems now to be a more holistic framework. So the Court of Appeal seems to apply a holistic approach, which is used, for example, in the UK or Germany. And they seem to distantiate from the problem and solution approach, which is applied by the EPO and in other EP countries such as Italy, France, or the Netherlands. So whether the different approaches at the end lead to different outcomes will need to be seen in the future. Our experience in Germany with the holistic approach is that the holistic approach tends to be rather patentee unfriendly compared to the problem and solution approach at the EPO. Whether the approach of the Court of Appeal also will be rather patentee unfriendly in the future needs to be awaited. Clearly, in this particular case, the approach of the Court of Appeal was patentee friendly as inventive step was acknowledged, but it does not seem to be a consequence of the holistic approach, rather a consequence of applying the reasonable expectation of success criteria, which is common also with EPO as well as in Germany. Very briefly, this case, I don't want to go into the technical details. What is important is that on the same day of the issuance of this decision, a second panel of the Court of Appeal issued this decision, also of inventive step, on the merits, and they applied exactly the same framework, showing that the two panels of the Court of Appeal, they aligned themselves before issuing the decisions on the same day, making clear that the framework I presented earlier is a framework which is shared by the panels of the Court of Appeal, and this is basically also a framework which will apply independently on the technical field, because the Amgen Regeneron case was a pharmaceutical case. This one is a mechanical case, and both cases apply the same framework. So this is clear that the framework presented by the Court of Appeal will apply irrespectively of the technical field. And with that, I would close this section on inventive step. And Shitani-san, I don't know whether you would like to summarize briefly what I presented.
Okay, thank you so much. 今、2つのケースについてお話しいただきました。1つ目がアムジェン対、アムジェン対レジェネロンってところか。で、これが、コレステロール低下薬に関する訴訟です。で、2つ目がメリル VS エドワーズっていうので、これが人工の心臓弁に関する争いです。で、1つ目のですね、アムジェンの方は、UPC になって初めての、無効の審理というところでございます。で、第一審では、無効ってされたんですけど、控訴審が行われて、で、結果として特許は維持されたということです。で、ちょっと個別の判断は、省略しますけども、今回ですね、UPC での控訴審で示された、進歩性に関するアプローチでいうと、EPO と比べると、よりその包括的なアプローチです。で、EPO の場合だと、いわゆるプロブレムソリューションアプローチっていうのが、使われてて、で、最も近い、近いクローゼストプライオアートっていうのが選ばれるというようなところで、厳格にステップごとに分析されます。で、一方で UPC の場合は、もうちょっと包括的で、英国とかドイツの裁判所で使用される手法に近いとのことです。で、その事後的な分析、いわゆるハインドサイトっていう後付けを厳しく排除してます。で、あとその合理的な成功期待っていうのを重視してて、で、成功期待って何だっていうと、その搭乗者であれば、やるであろうっていう、could じゃなくて、ちゃんと組み合わせるであろうっていう would、そういうところをちゃんと権利者が主張すべきだっていうようなアプローチです。で、判断の、手順は違うんですけども、結論はおそらくこのケースに関しては一致してただろうということでございます。で、2つ目の事件、メリルの事件で、これは人工弁なんですけど、これはUPC の、運用開始日の初日に提訴されたって書いてますね。こっちの方が早かったのかな。で、無効訴訟と、侵害訴訟っていうのが並行して進んでる件です。で、これも詳細は割愛しますけども、結局、先ほどのですね、アムジェン判決と進歩性判断の枠組みっていうのは同じでした。なんで、これが多分しばらくは、その統一裁判所での判断枠組みになるんじゃないかなというところでございます。はい、以上です。Okay, so let's go ahead. This is maybe, I think, a final case, right? Fujifilm vs. Kodak.
Yes.
Yes.
Okay, so please.
I have the honor to present this shortly to you. This is Fujifilm versus Kodak cases. This is a complex of several cases where Fujifilm sued Kodak entities for infringement of several EP patents concerning planographic printing plates. As Meer, we had the pleasure to assist in these cases from the technical side as patent attorneys. So we have been live in these proceedings. And these, although these cases have only been decided in first instance up to now, they have gotten quite famous because they clarified the question of competence. So the defendants, the Kodak entities, were domiciled in Germany. However, some of the infringing acts were carried out in the UK. And as we explained in the beginning, UK, after the Brexit, is a non-UPC member state. And thus the question was, do the UPC local divisions in Düsseldorf and Mannheim, Germany, and UPC, have the competence to hear and decide on infringement cases that are actually concerning infringement acts in a non-member state, the UK. And if we show the next slide, then this explains where the doubts are coming from, because there are conflicting provisions. There is, on the one hand side, Article 4 of the Brussels recast provision, which says it should be based on where the defendant is domiciled. And then there are several exceptions to the rule. For example, for proceedings concerned with the registration or validity of patents, and irrespective of whether the issue is raised by way of an action, so invalidity action, or as a defense, that is a counterclaim for invalidity. So there were these conflicting regulations, and no one was sure whether the UPC was competent to hear the case. And if we go on to the next slide, this decision has become famous as the long-arm jurisdiction. Namely, UPC has a jurisdiction for infringement matters even in the UK. So there are a lot of other specific restrictions which can, again, limit their competence. But for this specific case involving the UK, United Kingdom, UPC has competence to decide. And this even remains unaffected by a counterclaim for infringement, for validity, the so-called yellow-marked defense. What it does not have competence to decide on validity matters, whether the patent is valid or not, the UK part of the EP patent. It does not have the responsibility to decide whether the patent is valid or invalid versus erga omnes, so versus a lot of parties, all parties. They are just competent to decide the infringement part of such a case. And doing so, the UPC will assess the validity as a mere prerequisite for infringement. So just examine very briefly whether it believes that the UK part of the patent is valid as well. And then after having done so, it is responsible for taking a decision on the infringement action, even for acts committed in the UK non-member state. That was what the Fujifilm cases were about. And with this, I have the pleasure to conclude this session from our end. We thank you very much for staying the evening with us and for your kind attention. Thank you.
Thank you for a very impressive presentation. I think this is the most impressive cases in your seminar. So, let me summarize. はい、ありがとうございます。最後、富士フィルム対コダックっていう日本企業同士のケースです。で、2023年に起こったケースで、デュッセルドルフとかマンハイムに継続していたということなんですけども、これちょっと訴訟の管轄権の問題に関するケースです。で、富士フィルムが原告で、コダックグルごめんなさい、コダックは日本じゃないか。で、コダックの、法人が、UPC 加盟国であるドイツに、ありますと。で、ところがですね、今回、侵害行為の一部が、UPC と全く関係のない、英国、EU ですらないですよね、そこで発生してますと。なんで、そこの、英国における、侵害部分に関して、富士フィルムはもう欧州の統一裁判所に合わせて審理してくださいっていうふうに訴えたと。なんで UPC が非加盟国である英国の侵害部分についてそもそも管轄権があるのかどうかっていうのがこの事例では争われております。で、結論としてはロングアームジュリスディクションって言って、長腕管轄っていうんですかね、長い腕の管轄っていうので、どこまで腕を伸ばせるかっていうイメージなんですけど、そうですね、今回、結論としては、被告がちゃんと UPC の 締約加盟国、ドイツに住所または居所があったということで、この統一裁判所は、非加盟国である UK における特許の侵害行為についても審理する権限があるというふうに判断されたということでございます。で、この解釈は、その欧州司法裁判所の判決とも整合しているっていうことらしいです。うん。で、あとはそうですね、ドイツの部分、これは違うか。で、あとその向こうの抗弁っていうのは、いけるそうで、例えばその被告が、UK、英国の中で、これは英国特許に関してこれ無効じゃないですかっていうのは、争うことは可能です。で、その場合は英国裁判所に別途無効の訴訟を提起する義務は、必要はないです。日本でいう103条みたいなもんですね。で、これを英国内で個別に行うことができると。そもそもこれ、耐性項っていうのはないです。あくまで、拘束力っていうのはインターパーツっていうことで、当事者間のみ有効ということでございます。この判断、非常に個人的には興味深いんで、ぜひ皆さん後でゆっくりと見返していただければと思います。はい、セミナーは以上です。はい、ありがとうございました。鹿島さん、いかがでしたか？
非常に素晴らしい講義で分かりやすく説明いただいて勉強になりました。ありがとうございました。
ありがとうございます。Okay, so Dr. Rumi and Miss Claudia, thank you very much for a very impressive and very sophisticated seminar today.
Thank you for your kind invitation, and we hope that you could enjoy our presentation.
Of course, yes. So maybe many listeners learn a lot of things from your slide, and so we now we start closing parts. So would you stay here until closing parts? Okay? じゃあ、はい。ということで、皆さん、今日はありがとうございました。かなりいろいろと情報が詰まってて、個人的には、プロブレムソリューションアプローチとは違う枠組みが提示されたってところと、あとはですね、最後の、裁判官察のところが非常に興味深かったかなと思ってます。ではですね、最後のクロージングを入ろうと思います。ちょっと待ってくださいね。これか。Okay, so would you stop screen sharing? 鹿島さん、今見えてますこれ？
はい、見えてます。
ありがとうございます。はい。ということで、次回、今年最後ですね。島津製作所の部長、阿久津さんによる生成 AI のお話です。阿久津さん、最近いろんなところでAI のお話をされまくってましてですね、今年の集大成ということで、かなり先進的な取り組みをされてらっしゃるので、ぜひこれは見てみてください。あと、登録まだの方もいらっしゃったら登録していただけるとありがたいです。YouTube に。はい。ということで、本日皆さんありがとうございました。いろいろとね、時間もなかったかと思うんですけども、もっと深い質問がされたかったら、直接ウェブサイトからお問い合わせいただければと思います。はい。それでは本日ありがとうございました。Dr. Rumi and Miss Claudia, thank you for very nice presentation. So, see you. So please, both of you, please stay. Okay?